Three things to know about patents. First is that it's first to file, meaning the first person who files the application, the earliest priority date, is the one that gets the patent. Anyone that files later for the same thing will not get a patent. And we are in a global system. And so even though when you eventually get your patent, the enforcement is just to the national boundaries of the country that you file in. For instance, you file in the US, you can get a US patent. You won't get a patent that's enforceable in Europe if you only filed in the United States. But your filing and your priority date is relevant to prevent someone in Europe from getting a patent. So this is one of the things that's confusing, is that when you're looking at dates and the way the system works, it's part national, but it's also global. It's global as far as disclosure. It's national as far as enforcement. And so that can be very confusing. But anyway, so we are still a first to file system globally. That is how it works. However, where you file determines where you have enforcement rights. So if you want enforcement rights in Europe, you need to file in Europe. If you want them in the US and Europe, and you're in the US, it makes more sense probably to file in the US and then file what's called a PCT, or a Patent Cooperation Treaty application, to get protection from that US patent in Europe, which ultimately means you'll end up with a European patent, hopefully, if it goes through. So that's the one thing to know about patent, is it's first to file. Second thing to know about patents, the claims of the patent define the coverage of the patent. And so what does that mean? When you look at a patent, you'll see that there's a whole bunch of words at the beginning. There's some drawings in there, and then at the end of the words, there's a section which has, usually it starts with I claim, and it has numbered paragraphs that are written in a very strange, tortured English. Those are the claims. And that is actually what defines what is patented. So when you're looking at a granted patent, and you actually are concerned about what is actually patented here, you look at the claims. Just skip ahead, pass all the drawings. That's not what's patented. It's the claims at the end. However, this is the third thing to know about patents, which is that all disclosure counts as prior art. All disclosure counts as prior art. Why does that matter? Prior art is what prevents someone else from getting a patent on what was previously disclosed. So this is the takeaway that I hope you're getting here, is that if someone discloses an invention but doesn't end up getting a patent on it, you don't have to worry about them enforcing something against you, because if they didn't end up getting a patent on it, there's nothing for them to enforce. However, their patent, their patent application, if it was published, whatever was disclosed in there can be used to prevent you from getting a patent, or your competitors, because that prior art, it's that filing date is what determines whether something is prior art. And if the thing that's earlier, remember first to file, if the earlier one discloses anywhere, drawings, words, claims, but it's probably going to be drawings or words, discloses something that you are trying to get patented, that will be prior art to your application, and you will have to change your claims to stay out of the way. So I hope that was helpful and not too confusing. Three things to know about patents. First to file, claims to find coverage, but all disclosure is what counts as prior art. I hope that was useful. Catherine Cavella, IP Works Law.